you.
Ladies and gentlemen, welcome to the National Constitution Center. I'm so excited to welcome you to this memorable and meaningful evening. I'm Jeffrey Rosen, the president of this wonderful institution. The National Constitution Center is the only institution in America chartered by Congress to disseminate information about the U.S. Constitution on a nonpartisan basis. And I cannot think of two Americans, who better embody the spirit of nonpartisan devotion to the United States Constitution than David Boies and Ted Olson. I will introduce them in a moment, but I want to ask you to return to the National Constitution Center for our upcoming programs. We have a blockbuster week next week, the final week of our spring programming. Lawrence Tribe will be here on June 24th, and on June 26th, we have the second in our great series of constitutional debates with Intelligence Squared about the constitutionality of restrictions on campaign finance reform. That will be Nadine Strossen and Floyd Abrams arguing against restrictions, and Zephyr Teachout and Bert Newborn arguing in favor. It's going to be a remarkable event. Right. I'd also ask you to download our wonderful We the People podcast. Every week we're summoning the best constitutional scholars in America to debate the constitutional issue of the week. The latest one got 100,000 downloads. They're building a national audience, and I would love to share them with you. Ladies and gentlemen, David Boies and Ted Olson, first of all, are special friends of the National Constitution Center. David Boies has long been on our Board of Trustees. Ted Olson has been a visiting scholar here and did wonderful debates with Lawrence Tribe about the Constitution. So it's meaningful to welcome them here. But although the Constitution Center is nonpartisan, and we believe that people should hear all sides of constitutional arguments and make up their own minds, I think it's descriptively accurate to say that you're seeing here two of the only people in America of their generation who are transforming the meaning of the Constitution. Just as Thurgood Marshall transformed the meaning of racial equality, and just as Ruth Bader Ginsburg transformed the meaning of gender equality, so David Boies and Ted Olson are transforming the meaning of marriage equality under the Constitution. And that is a remarkable achievement. This book, ladies and gentlemen, is riveting. It's a riveting book because it is full of passion. It is not a lawyer's book. It is not an academic book. It is a book, on every page, you understand that this cause is the most important of their lives. And that passion jumps out at you from the very beginning. Just listen to this introduction. We both felt deeply that Proposition 8 was wrong and fundamentally at odds with our vision of America, with our understanding of California and Californians. And then they said that we feel it is exceedingly important to share why we believe this endeavor was a critical step in the process of changing not only California, but we hope America and the world. And it is the passion of this book which is so palpable, and that is why I want you once again to welcome to the National Constitution Center, David Boies. All right, I got worked up. That was too long an introduction, but I felt that I needed to give it. Let me start.
It was okay.
Okay, good. Let's begin at the beginning. Ted, why'd you take the case? Tell the story.
I grew up in California. David did too. It's interesting that both of us were born in Illinois, but we moved to California at a relatively young age. We both went to public schools in California. We both went to college in California. David came east to go to law school. I stayed in California to go to law school. But I feel that and I've lived in Washington for 30-some years now, but I still feel that I'm a Californian. I think of California as the mountains. I think of the people that moved to California to be a frontier. The redwood trees in California, the Pacific Ocean and all of those things. I think about California. It's a remarkably diverse state with an immense population of Latinos and Asians, and I mean every nationality you can think of. And we all grew up in California believing in its diversity and its richness and its individuality and the belief in the human spirit. And so I was stunned, I think, as a lot of people were, when on November 8, 2008, Californians overruled the California Supreme Court and took away what the California Supreme Court had done, which was to recognize the right of gay and lesbian citizens to marry the person that they love in California. I was stunned by that. I just didn't think it was California. I didn't think it was consistent with my understanding of what this country is all about. And I didn't vow to do anything about it, but not long after that, I was contacted by people in California who were determined to bring a federal constitutional challenge to Proposition 8 on the grounds that it violated the 14th Amendment protection of fundamental rights and equal protection and the due process of law. And when I was contacted, I was really secretly, I didn't never imagine that anybody would contact me to do this, but when it happened, I really welcomed the opportunity. I consulted with my wife, I consulted with my partners, I consulted with others, and I felt that if we can do this the right way, someone's going to bring a challenge to Proposition 8 in California. If we can do it the right way, put our resources and our experience together to overturn Proposition 8, what we can do for the people in California, and by extension, people everywhere, because of the ability to overturn. California is the most populous state. California is the leader in things that happen all over the country. And if we can take away that stigma that Proposition 8 attaches to people who want to marry the person they love, what a great thing that would be. And I will come to this unless you want to ask it. I thought that because of my background, I thought it was exceedingly important to have someone who's recognized on the other side of the political spectrum. David and I had come to become very, very good friends. I recognize David as, in my opinion, the finest lawyer in the world, and someone who's an absolutely fantastic person, someone that you want to be around, someone that you want to exchange ideas with, and someone who would send the signal when we took this case on that this was not about conservatives or liberals or Republicans or Democrats. This was about American ideals, and if the two of us could come together and get the kind of attention I hoped we would get, that would send a signal to the courts and send a signal to the American people that this is something that had to be changed.
David, as you describe in the book, both of you had been on opposite sides of Bush versus Gore, but since then you became friends. How did you feel when Ted asked you to take the case? And also describe, how invested were you in the cause of marriage equality at the time? You described having been in New York at the time of the Stonewall riots. You said you marched in one parade, but not many since then. What was your state of mind when Ted approached you?
Well, I think Ted has stated about as well as anybody could, which is one of the reasons it's so good to be on the same side as he is. I know what it's like to be on the other side. I've got the scars to prove it. But when he called me, it didn't take me as much as a second to say yes. I felt exactly the way he did about Proposition 8. I had been involved in civil rights work for a while. In the 1960s, I'd been in Mississippi for what I thought at the time was the defining civil rights struggle of that generation. I believed that this was the defining civil rights struggle of this generation. And so having the opportunity to participate was something that I enthusiastically accepted. I think to the second part of your question, though, at the time I was intellectually convinced. I was convinced as a matter of constitutional law. I was convinced as a matter of civil rights and human rights. I had watched in 2004 when Gavin Newsom, who was then the mayor of San Francisco, opened up the clerk's office and began issuing marriage licenses to people who wanted to get married regardless of their sexual orientation. And I remember people lining up, traveling there from all over the country, all over the world, stand in line all night to get a marriage license. And I remember thinking and talking to my wife Mary about asking, what in the world were we doing as a society, depriving people of this most fundamental relationship, this most fundamental right to marry the person that you love, something that the United States Supreme Court over and over again has described as perhaps the most fundamental and most important relationship in anybody's life, something that is essential to human dignity, to the pursuit of happiness, to the equality that the framers wrote into the Constitution, although not always into their lives. I think that in the beginning, in 2009, it was an important case for me. But I think as the case went on, and I think Ted felt the same way, we became more and more emotionally involved in the case. As we got to know our plaintiffs as people, as we saw the pain, the damage, the discrimination did to them and the children that they were raising, I think this became a much more emotional journey than either of us thought at the time we started it.
Ted, when you decided to take the case, it was not constitutionally obvious to many people that marriage equality was required by the Constitution. And you were urged not to take the case by many supporters of marriage equality who thought that you might suffer a big defeat and set the cause back. What convinced you that it was the right thing to do, and describe your trial strategy that proved to be so successful?
We were importuned by organizations that we respected who'd been fighting for civil rights for gay and lesbian persons for years and had accomplished great things. People who we respected a great deal, who had developed a strategy. They felt that moving slowly or cautiously, deliberately, I shouldn't say slowly, to develop a momentum on a state-by-state basis, more court decisions, more legislative victories and things like that before the case got to the Supreme Court, because they were very worried that if brought to the United States Supreme Court too soon, a defeat would be devastating and would set the cause back for a long period of time. We listened to them. We cared a great deal of what they had to say. We respected those individuals. But we'd been asked to represent individual human beings who felt in California that this was a devastating blow to members of the citizenry in California who were being told that their relationships were second class, that engraved in the California Constitution by a vote of the people, they were not equal, that their relationships didn't count. Their relationships were not recognized. Their children couldn't call their parents married. So people came to us, and we thought several things. One, someone is going to bring this case. You can't imagine the state of California, of all the people that wanted to get married, that some couple wasn't going to bring a federal court challenge. Someone was going to do that. And some lawyer in California, believe me, I practice law in California, there are lawyers that would do this case. So someone was going to bring this case, and that case might wind up in the Supreme Court. And I've had some experience in the United States Supreme Court. I've seen good lawyers there, and I've seen lawyers that were less prepared there bringing cases that weren't sufficiently well-grounded and prepared, and the consequences can be devastating. So if there's going to be a case, which there will be, that might get to the United States Supreme Court, I thought that the team we put together could do it in the best possible way. Secondly, you can't look people in the eye and say that you think that your constitutional rights are being denied, and we thought that they had a constitutional right, and then to say no, wait. But the wait until when? Wait until the United States, the composition of the Supreme Court changes? before the more recent appointments, starting with the Chief Justice and Justice Alito, there was 12 years before there was a vacancy on the Supreme Court. Who's going to be elected next president? Which is the next justice to leave? No one could say, well, when would be the right time to bring this case? Thirdly, we spent a lot of time studying previous civil rights battles and the writings of various people, including people that had represented the cause of marriage equality, but also great leaders like Martin Luther King, who referred in his I Have a Dream speech and his letter from a Birmingham jail when he was addressing members of the clergy that were telling him to slow down, you're risking a backlash. And he referred to this as the tranquilizing drug of gradualism. This is why I have David. And he said in that speech and in that letter that people that tell us wait, they mean never. And he also went on to say that civil rights battles are not won by people who are afraid of losing, of defeat. Civil rights battles are won by people who are willing to challenge what is happening in the status quo. And the final thing, I'm sorry I'm taking too much time on this, but when is it going to be time for the people in Mississippi or Arkansas, where states were much more reluctant than California might be to change things? When was that going to happen for those people and their children and their loved ones? It was going to take a long time. And so we decided that this is something that notwithstanding the good advice that we got from people who respected us, don't take a chance, we felt that it was the only thing that we could do. And we put the resources of David's law firm and the resources of my firm on this case to do the very, very best that we could.
David, you talked about how emotionally invested you became in the case. And there were obviously many emotional moments during the trial. And there are many emotional moments in this book. But there was a particularly memorable moment when you asked one of the plaintiffs, Jeff, to describe his feelings about Paul. And you have the transcript, and I want you to read what he said.
Yeah. One of the things, just as background, one of the things you always do in a case is you prepare your witnesses to testify. And you particularly prepare them for cross-examination because you want them to understand the hard questions they're going to get. You want them to understand what the potential answers are, and you want them to understand what the traps are. And you also prepare them for their direct examination because you want the examination to go relatively smoothly. But you don't want to over-prepare witnesses, particularly when they're trying to convince somebody of something that's personal, because you never want a witness to come across as if they're rehearsed, as if this is simply a repetition of some script that they've been given. And in preparing our plaintiffs, and we decided that our first 4 witnesses would be our plaintiffs. That's a risky strategy, because if the trier of fact, judge or jury, doesn't like your plaintiffs, and you get off on the wrong foot, you may never begin to recover any momentum. We decided that it was their story, and we needed to put a human face on the discrimination and the pain, and the frustration, and the damage the discrimination was doing. And so we decided we'd put the plaintiffs on first, and we went through a long preparation period of preparing them for a lot of the hard questions that they were going to get asked. But we purposefully did not prepare them for some of our questions because we wanted those questions to come as naturally and from the heart as they could. And the first witness that we called was Jeff Zarrillo. And I put him on, and I asked him a few background questions. And then I asked him whether he wanted to get married. And he said yes. And I said, who do you want to get married to? and he identified Paul. And I then said, tell me a little bit about that man. And I tell you, I get emotional about this. And Jeff replied, he's the love of my life. I love him probably more than I love myself. I would do anything for him. I would put his needs ahead of my own. I would be with him in sickness and health, for richer, for poorer, till death do us part, just like the vows. I would do anything for him, and I want nothing more than to marry him. And I tell you, when he got finished, there was not a dry eye in that courtroom. And I include the counsel on the other side and the judge. And each of the plaintiffs that came told not exactly the same story, but told a similar story. One of the women plaintiffs that Ted put on talked about how if she'd been able to marry her whole life, if she'd known that she could marry and this discrimination had been wiped away, her whole life would have had a higher arc. And she talked about the damage that was being done to young people all over the country because they were being stigmatized as second class. And we could have stopped the trial after those 4 witnesses. We didn't. We brought in world-class experts in psychology and economics, sociology, history, to testify, to build the record that we needed to build. But the heart of that case and the soul of that case was the testimony of our plaintiffs.
Ted, you have a chapter describing David's cross-examination, and he has a chapter describing your remarkable closing argument. I want you to talk about David's cross-examination and how he systematically forced the opposing witnesses either to recant or withdraw. It was a remarkable performance.
The judge in this case was the chief judge of the Federal District Court in Northern District of California. He'd been on the court for a long time. He'd been appointed by a Republican president. And ironically, he was opposed for his confirmation because as a partner in a law firm in San Francisco, a major law firm in San Francisco, he had represented the Olympic Committee who was fighting against the Gay Olympics, or the use of the name Gay Olympics, because of the trademark and those kind of issues, and they thought he was anti-gay and lesbian individuals. It turned out that he himself late in his life, realized that he was gay. And this was known to people, so it wasn't something that was a surprise to people. But he was very much a trial judge. And when we made motions at the very beginning of the case for preliminary injunctions and summary judgments and so forth, he said, no, there's very important issues in this case. I am a trial judge. There's a reason why I'm here. This is going to go someplace else. He said it's more important how we do it than how we come out. And he said, so I'm going to have a trial. And he said, these are the things that I want witnesses to testify about. What is the history of marriage? What is the impact of discrimination? What is the stigma that's caused? I want experts or witnesses to tell me about the raising of children. What's happened in other countries when there's been a recognition of the right to marry someone of the same sex? All of those things, the political power of individuals. How do I decide the standard of review? Is there a history of discrimination against gay and lesbian individuals? So he said, there's going to be a trial. I'm going to move it quickly. We filed the case in May, and the trial was in the following January. So we found the best experts in the world. We turned to people that had expertise and had studied and written books about all of those subjects that I just mentioned. And the defense, of course, did the same thing. And we each had the opportunity to take the depositions and conduct discovery of our opponent's expert witnesses. The witnesses had to prepare reports. Many of you know how all this is done. And then there's a deposition, and opposing counsel can ask questions. Well, David, And we listed 8 witnesses, all of whom we put on at the time of trial. On the other side listed 8 to 10 witnesses, I can't remember how many, and we took the depositions. David and members of the team took the deposition of those witnesses. And many of them were videotaped. And if you happen to have the opportunity to see the HBO documentary called The Case Against 8, which we broadcast next Monday, for God's sakes, please see that documentary. It's the most compelling thing that I can imagine. We had a film crew following us from the beginning of this case, and they capture all of this, and you will see what I'm about to describe. So David takes, and others, but principally David, take the depositions of their witnesses. And David, who is just a genius at this sort of thing. It's Michelangelo, maybe that's a little strong. But it's an art. And we all think of the lawyer gets up and does cross-examination and the witness dissolves in tears and confesses. That does not happen in real life. The judges know that. But it does happen once in a while. And when it happens, it's often David Boies. If you've ever watched or read about the Westmoreland trial and David's cross-examination of General Westmoreland, and many of you saw David's cross-examination of Bill Gates in the Microsoft case. Well, anyway, it happened again in this case. So these witnesses that David very gently and properly and carefully took through their paces and asked them about their qualifications and their opinions and so forth, wound up on videotape, admitting many of the things that were important to our case. And when it came time to the trial, most of those witnesses found that they actually had to be someplace else. One of them said, "You think I'm going to go through that again with him?" The lead witness was a man by the name of David Blankenhorn. And I described my chapter. We each wrote 2 separate chapters in the first person just by ourselves, why I took this case, and then I talked about in my other chapter David's cross-examination, because I was thrilled to be able to sit there. Each of us have been practicing law for collectively about 100 years. So I've seen a lot of things, but boy, the chance to be in court with David Boies doing cross-examination was something I wasn't going to miss. Well, Mr. Blankenhorn was an expert, he felt, on the subject of marriage. He'd studied it, and I'll let David talk about what his PhD was in. But David carefully, and you have to, the judges know this, if you harangue a witness, if you lecture a witness, if you're brutal or unfair or sarcastic, the trier of fact, whether it be a judge or jury, will sympathize with the witness. You'll lose the opportunity to get any ground. David's very patient and very nice, except that you know what's happening in that courtroom. And he, in this movie, you'll see him, he actually admitted, he said, it was like a train wreck coming. I knew it was coming, I could see it coming, and I couldn't do anything about it. At the end of David's cross-examination, Mr. Blankenhorn, who I have respect for because he's an honest person, he was telling the truth, but he couldn't avoid saying at the end of his testimony that children in a family being raised by 2 persons of the same sex would be better off if their parents could get married, if the people that they lived with were better. So all of the business about children in a household needing a mom and a dad, and it would be bad to have a gay and lesbian parent, was blown away. And then finally, and I'll come to this point, at the very end, he said, in this country, we would be more American, we'd be more true to our ideals the day we allowed a person to marry the person that they loved of the same sex. Well, what was left of the case? This was their expert witness that they were putting all of this on, and David sat down, and we didn't want to jump up and scream in the courtroom. It's not permitted, but in our hearts, we were saying, my God, David's beautiful, patient cross-examination decimated the other side's case.
So after the argument, David Blankenhorn wrote an op-ed in the New York Times recanting his opposition to marriage equality and coming around to your side. And since then, more recently, Charles Cooper, your opposing counsel, has also recanted his constitutional opposition to marriage equality. So you did a pretty good job. I want you to describe, David, the key constitutional moments in the trial. You talk about one concession that Charles Cooper made early on. Take us through the highlights of the trial and then tell us about Ted's magnificent closing argument.
Well, we set out at the trial to prove three things. And we thought that if we proved those three things, perhaps just two of the three, but certainly if we proved all three of those things, we had a very, very strong constitutional argument. First, we set out to prove that marriage was a fundamental right. And that was actually pretty easy to prove because the Supreme Court had said it over and over again. And they'd said it in a variety of contexts. They'd said it in Loving against Virginia, which was a case in 1967 in which the United States Supreme Court unanimously invalidated Virginia's constitutional provision that prohibited interracial marriage. They'd said it in a case from Wisconsin, in which Wisconsin had passed a law that said if you're not paying the child support that you owe from a prior marriage, you can't get another marriage license. Rational state policy. Supreme Court said that's not enough because marriage is such a fundamental right. It's so inherent in the dignity of individuals and their pursuit of happiness that you cannot deprive even somebody who's abused first marriage of the right to get married again. Missouri had a statute that prohibited people who were felons incarcerated in prison from getting married. And they said there's no purpose in these people getting married. They can't consummate the marriage. They certainly can't procreate. And besides, they're felons. They've lost the right to vote. They've lost all these other rights by being convicted. And the Supreme Court said, yes, but marriage is such a fundamental right. It is so essential to the dignity and the liberty and the right of association of an individual that you can't take it away even from convicted, imprisoned felons. So we established that marriage was a fundamental right. The second thing we set out to do is we set out to establish that not permitting gay and lesbian citizens to marry the person they loved seriously harmed them and seriously harmed the children they were raising. And we proved that from our experts that we brought in from around the world, but also, as you heard, from the mouths of the defendant's own witnesses. And third, we set out to demonstrate that depriving gay and lesbian citizens of the fundamental right to marry didn't help anybody, didn't improve anybody else, heterosexual's marriage, didn't preserve the marriage of anybody who otherwise was not going to get, who was otherwise married. I used to, in fact, I had a debate here at the Constitutional Center in 2009 against some of the opponents of marriage equality. And I asked the audience, I said, how many of you are married to a person of the opposite sex? And a lot of hands went up. And I said, okay, now put those hands down. Now, how many of you would get divorced if your gay neighbor could get married? Not a single hand went up. And I said, well, how many of you have children who are in love and want to get married? And a fair number of hands went up. And I said, okay, now how many of you think your children would decide they didn't really want to get married after all if they found out that their lesbian classmate was going to be able to get married? And not a hand went up. So this was pretty sensible common sense. But we got a bonus because the judge asked our opponent, Chuck Cooper, what kind of harm is there in allowing people to get married, allowing same-sex marriage? Can there be a harm in doing that to heterosexual marriage? And Cooper, who's a very good lawyer, knew that this was not a question that he wanted to answer. And so he danced around it and he avoided it. And the judge got more and more persistent. And as the judges know who are here, and as lawyers who are here know, when you don't answer a judge's question, they can get cross. And you really don't want that to happen. And so the dancing got harder and harder for him. And finally, the judge had said, Mr. Cooper, is there any harm that will result from permitting same-sex marriage? And Cooper paused, thought about it, and finally said, I don't know. And he said later those were words that he wished he had never said, and he'd like to have taken them back. But the fundamental thing is, even after that, he still couldn't come up with any harm. And so we demonstrated what we thought were the three things that we had to demonstrate in order to win. Now, in a trial, everything that goes on in a trial is or should be pointed to one point, and that is the closing argument. You know, for a politician, the moment of truth is election day. For a salesman, it's when you go and ask for the order. For a trial lawyer, the moment of truth is the closing argument, because that's when you take everything that you've done, all of the evidence that you've put in, the experts, the fact witnesses, and you try to tie it together, and you try to tell the judge why the judge ought to decide for you. And when Ted got up to give, and when you're the plaintiff, as we were, you go both first and last. You go first because you've got the burden of proof. The defendant gets there to make their argument, and then you get a chance to respond to the defendant's argument. And Ted's argument, when he got up to start, was a great argument. It pulled it all together. It was persuasive. It tied the evidence in with the law. On the other hand, while Ted does this better than anybody else I've ever seen, that part of the argument really wasn't that remarkable because he had a lot of time to prepare for it. He worked on it, he prepared for it, he learned it, and he did a magnificent job. But later, after Cooper argued, and Cooper did a good job too, Ted had what I think is one of the hardest things to do in any trial, which is after your opponent has given their argument, you need to get up and do two things. You need to remind the judge what your main points are, and you need to rebut what your opponent has just said. And you need to do it in a short period of time, 20 or 30 minutes at maximum. And you have to do it without any chance to prepare. Cooper sits down, Ted gets up, and he's got to start talking. And he doesn't have any opportunity to write it out, even outline it. He's got to get up and he's got to give that argument. And that 30 minutes, in this case, in the Perry case, was the best 30 minutes of argument I've ever heard. It hit every point that Cooper had made. It showed why the law was against him and the facts were against him. And it brought the judge back to each of our themes. And in this case, the demand to get into the courtroom was so large that the judge had another courtroom assigned as an overflow courtroom. And in that courtroom, they beamed in a closed-circuit television signal that showed the people in the overflow courtroom what was happening in the actual courtroom. We actually tried, and the judge agreed, and the Ninth Circuit agreed, to let that broadcast signal get distributed outside of the courthouse. But the Supreme Court 5-4 turned that down. so the public never got a chance to see what was going on in the trial, which I think was a great tragedy. But everybody in the courthouse, including that overflow courtroom, got a chance to see it. And in a courtroom, there's a lot of decorum. In a federal courtroom, there is infinite decorum. You don't get up and talk. You don't make loud noises. You don't cheer. You don't even make appreciative sounds. And when Ted got finished and turned and came back and sat down, the most that happened was I just reached over and thanked him for what he had done. But in the overflow courtroom, people are not so constrained, and people got up and started to cheer. It was that good. And it was clear to me after that argument that there simply was no ground that was left for the other side to stand on. And when the judge wrote his opinion, which is a great opinion, and everybody ought to read that opinion, and it ought to be distributed in schools, in civics classes, because it talks about the transition of this country towards greater and greater equality. And it talks about how marriage has been a part of that journey. And it talks about how marriage has become more and more an equal institution in terms of eliminating the discrimination against women in married situations, eliminating the discrimination based on race, and now eliminating the discrimination based on sexual orientation. But that opinion was drawn from Ted's closing argument. And you can see the outline of that opinion in what Ted put together. And the ability to do that is a very unusual ability. And it's great to see it. And it's particularly great to see it when you're on the same side.
Ted, this is the National Constitution Center, and I want to take another beat on a hard constitutional question that Justice Scalia asked you during the Supreme Court argument. He asked you, when did it become unconstitutional to restrict marriage to a man and a woman? And you said, when did segregation become unconstitutional? You asked him a question in return. You went back and forth a couple of beats. In the book, you suggest we have a new understanding. People came to understand that sexual orientation is immutable, and that was a changed meaning of the Constitution. Does that mean that in order to embrace marriage equality, you have to be a living constitutionalist? And is it possible to be an originalist like Justice Scalia and still to embrace marriage equality?
Well, that's a very good question, and was a very interesting part of our argument in the Supreme Court. I think all of you know that what you do when you're going to go to the Supreme Court, you practice. We, David and I, believe in preparation. There's no excuse not to prepare hard. Everything that we do, we believe in preparation. There's no excuse. You have to use your skill, you have to use your instincts, you have to use your education and all the things that you've read and learned, but you practice. And we did moot courts over and over again for that Supreme Court argument. In the Supreme Court, in the United States Supreme Court, it's particularly important to prepare because there are, of the 9 justices, 8 of the justices are pretty much guaranteed to be asking you questions. You have a short period of time. This is, I like to say that, they've been locked in those chambers back there and they're finally allowed to get out. And they get out, and this is an opportunity for them to really, do what they do, and there's this raw meat standing right there, and they want to jump on you. And so they will ask you questions, and we love this because it's an opportunity to engage in a dialogue. That's preparing an appellate argument is kind of frustrating if you just stand there and give a speech that you don't know whether anybody's listening. Of course they are, but you don't know what is in their mind, what they're concerned about. In the Supreme Court, they give you that opportunity in spades. You start off by saying, Mr. Chief Justice, and may it please the court. I have been interrupted before I said, Mr. Chief Justice, and may it please the court. Before you say that, Mr. Chief Justice part, tell us this or whatever. So you prepare to be interrupted. You prepared for them to interrupt one another and ask these questions. And so every aspect of this case we went over, and we'd done it in the trial court. We'd done it in the Ninth Circuit. We'd redone it in the Ninth Circuit, and so forth. But you could never really be fully prepared for the Supreme Court. And Justice Scalia was someone that we had a mild instinct that was really not going to be on our side at the end of the day. We were hoping to persuade all of them. David and I said right from the beginning we were going to take no justice for granted. We were going to give up no opportunity. We wanted to persuade everybody. But as it turned out, Justice Scalia did jump on me and said, well, when, Mr. Olson, did it become unconstitutional to limit marriage to a marriage between a man and a woman? Of course, there's no good answer to that question. So, and my preparation helped a little bit, and you're responding to instincts at that time. So I said, well, when did it become unconstitutional to prohibit restrictions on marriage between persons of different races? Or when did it become unconstitutional to require children to go to school in segregated schools? My point was that it became unconstitutional when the court decided that, but there's no moment in history when all of a sudden it became magically unconstitutional. And Justice Scalia is someone who prides himself on being an originalist. What did the framers of that statute or that constitutional provision have in mind? And we had some additional dialogue, as you know. He's not quite done addressing this question either. He still talks about it from time to time. But with respect to the Equal Protection Clause, no one was thinking about marriage. No one was thinking, when the Equal Protection Clause was enacted after the Civil War, children were in segregated schools, and that went on for a long, long time. And so my point was, and I'll try to make this short, because the Constitution, the requirement of due process of law before taking away fundamental rights, the process of what is an unreasonable search and seizure, the process of deciding what's cruel and unusual punishment, the process of deciding what is just compensation when the government acts in a way that affects property, the process of deciding what is equal protection of the laws, the protection of equal laws, depends upon a lot of things that we learn about the application of those laws. In today's society, the Fourth Amendment is constantly having to be rethought because of all of the changes in methods of surveillance and cameras everywhere and all of those things. I won't go on and on about that. But the same is true about the Equal Protection Clause and the Due Process Clause. And so we have learned what sexual orientation is. We didn't know a lot about it. People didn't talk a lot about it. But we now know, and we proved it in this trial, that individuals don't just choose to say, I think I'll be gay. You know, I think I will be. Someone asked me, I thought one of the best questions someone asked me during this case, did you choose to be heterosexual? And of course, no, I didn't. You know, it's me. It's baked into me. It's baked into the individuals who are gay and lesbian. And so when we're discriminating against them, when we're denying the access to rights that society provides to other people, we're taking their characteristic of them as an individual, and it could be race, and it could be something else. It could be legitimacy, which the Supreme Court has addressed. And we're cutting them out of society's rights because of who they are. That's a violation of the Equal Protection Clause, and that's what that dialogue was all about. And you don't have a chance to elaborate and explain to the degree that I've just done in the United States Supreme Court because it's machine guns being fired at you. So anyway, I was doing the best I could.
David, you and Ted have helped change the court's understanding of the Constitution. When I started teaching constitutional law in the midst of the early 1990s, the right answer on an exam was that you could restrict marriage to a man and a woman, but then the court decided that moral disapproval was not a legitimate reason for laws, and then it decided in the Virginia military case that preserving tradition for its own sake was not a legitimate reason. So How does the Constitution change? Was it your legal arguments? Was it the shift in public opinion? You say in this book that it's exceedingly important that citizens understand this story. What is it exceedingly important that you want people to know about how the Constitution changes?
In terms of the Constitution, I think what doesn't change are the fundamental principles of the Constitution. I think to some extent everybody is an originalist and nobody's an originalist. Everybody's an originalist in the sense that you go for the original intent of the principle that's involved. Freedom of speech, freedom of the press, prohibition of cruel and unusual punishment, equal protection and due process. Those are all original principles that I think everybody believes is an essential part of our constitutional protection of individual liberties. Nobody in the 1700s conceived of radio and television. And yet there is no doubt that freedom of speech and freedom of press applies to radio and television. When the Eighth Amendment's prohibition on cruel and unusual punishments were adopted, we did all sorts of things to people of all sorts of ages that are now constitutionally prohibited unanimously by the Supreme Court. The Supreme Court unanimously applies freedom of speech and freedom of the press to radio and television. When the 14th Amendment was passed, not only were schools segregated, but interracial marriage was prohibited in virtually every state. So at that time, if you asked the person who was passing the 14th Amendment, do you think that this eliminates bans on interracial marriage? Do you think this eliminates segregated schools? Do you think this eliminates bans on same-sex marriage? Their answer would have been no. But that's because they were applying that enduring principle to the society that they were in at that time. And as those societies change, you have to change the application. As John Marshall said, you can't forget that it's a Constitution that we're interpreting. And so no one, I think, would say, well, we're going to continue to execute juveniles because they did it at the time of the Eighth Amendment, or we're going to continue to have capital punishment for the wide range of offenses that they had at the time of the Eighth Amendment, or that we're not going to apply freedom of speech and freedom of the press to radio and television because they didn't exist, or we're going to permit states to ban interracial marriage and to have segregated schools because you had that at the time that the 14th Amendment was passed. So nobody, as I say, is really an originalist, but in a sense, everybody is an originalist because we all go back to those basic principles, but we all agree that they need to be applied to the society that we have now. And how you apply them to the society we have now is really what the disagreement and the debate is about.
We have superb audience questions and a little bit of time for them. I'm going to ask, well, first I just can't resist asking, Ted, do you agree with David's constitutional statement?
In most cases, he gets it wrong when he applies that to Bush versus Gore.
Excellent. All right, let's take some of our great audience questions. Ted, I'll ask it, the first one to you. If marriage is a fundamental right, why does the government need to legislate for it?
Well, government has traditionally regulated and conducted scrutiny of the relationships that are covered by the First Amendment. There's government regulation of speech. There's government regulation of, we've learned from the Supreme Court in the Second Amendment with respect to the right to bear arms. There are reasonable government regulations. So Government has always regulated the institution of marriage, provided what the benefits are, provided tax breaks, provided regulation that deals with children, custody of children, the end of marriage. The Supreme Court has addressed that too, a constitutional right to marriage, sexual relationships between individuals. So because there's a fundamental right does not mean it's an absolute thing. And so the short answer to that, and I know you want to keep this short because there's a lot of good questions, is that there are rights under the Constitution, all kinds of rights under the Constitution. But I come back to reasonable searches and seizures or other things. The government has a role here. The thing is that when it comes to a fundamental right, the government has to prove a high standard of why this regulation is being imposed and that it is sufficiently narrow only to accomplish the government's legitimate objective and not to go further than that and not to be unduly restrictive.
David, this question says, do you think Justice Scalia regrets his comment in Windsor that the decision makes it inevitable that state law prohibitions of same-sex marriage will be overturned, since it's been cited so frequently in decisions finding the statutes unconstitutional?
Well, you would think he might, except that when you make exactly the same statement 10 years in a row, you probably know what you're getting. And Justice Scalia made essentially that same statement in his dissent in Lawrence against Texas. That was decided exactly to the day 10 years before the Windsor case. In Lawrence, the Supreme Court held, and Lawrence is a tremendously important civil rights precedent. It's the first Supreme Court case that holds that the due process and equal protection clauses protect people of different sexual orientations. And in that particular case, the issue was whether Texas could criminalize homosexual conduct. The Supreme Court held 5-4 that it could not under the Constitution. That was a relatively narrow issue, but the reasoning of the court was very broad. And Justice Scalia, in dissent, said, this means that the court has just dismantled any constitutional prohibition on having same-sex marriage. He said, if you can't constitutionally do this, you can't constitutionally limit marriage to people of different sexes.
What happened in our trial was that I cited that Justice Scalia comment in the Lawrence case to Judge Walker, and he said, well, that was because Justice Scalia said this decision means that marriage would be okay. I mean, would be protected. And Judge Walker said, well, that was a dissent. And I said, precisely. So, see, as David says, he said it again in the Windsor case, and you judges know that they've been putting that right in front of district judges, and he must know what the Supreme Court was deciding.
Because he was
precisely.
It was a remarkably prescient comment in Lawrence. I think he predicted the end of laws restricting bestiality, same-sex marriage, and masturbation. And it came as a surprise to many people that this was illegal. Just one or two more questions. Actually, I think a law clerk did some research, and it was assisted masturbation. It was prostitution, essentially.
You didn't tell us you were going to get into that.
Exactly. It's the Constitution Center. No subjects are too tough for our sophisticated audience. I think, David, you're next. Please explain to those of us who don't buy into the rationale of expanding the meaning of marriage why your position doesn't place emotional and sexual preference above the universal and natural reality of gender distinction.
Well, the universality of gender distinction tends to be in the mind of the beholder. There are no doubt people who have genuine, sincere, moral and religious beliefs that marriage and indeed sexual activity should be limited to people of opposite sexes. And the First Amendment of the Constitution guarantees that freedom of belief. But the First Amendment also provides that no one can impose those beliefs on somebody else. And so when the government, as opposed to a religious institution or opposed to an individual, begins to discriminate among its citizens, it's got to have a basis for doing that. And what it can't do is discriminate against citizens in a way that seriously harms them and their children without a legitimate secular purpose, not religious purpose, but secular purpose. And that's what we proved at the evidence at trial, that there was no legitimate secular purpose for that. And that didn't mean that we were saying that people should change their religious beliefs. What it meant was that those religious beliefs, there was not a secular basis for applying those religious beliefs to other people's lives.
Ted, I think I'm going to give you the last question. What role or what message, if any, did having two attorneys that were not from the LGBT community play in the case, do you feel it made any difference?
Okay, well, that's a very, very good question because so many of the advances that have occurred over the years have been people, LGBT attorneys and institutions, organizations that have labored in the vineyard and made so much progress. And so now this case comes along, and one of the things that I've been told made a difference is that two old, white, heterosexual males bringing this case, what difference did it make? And I think some of the differences that it made, it complemented what had been done before. And it changed the chemistry a little bit in this sense that because David and I've already mentioned this, we're from opposite ends of the political spectrum, it took out of the debate the idea that this was a cause, a relatively narrow cause by people that had special interests and special impact upon their lives, and they were fighting for their rights. A lot of people could just close their eyes to that and ignore it. It's them fighting for rights for their group or the people that they represent. One of the things, and it just allowed us to visit and talk about some of these things because we brought a different dimension to this thing, and it was less of a special interest thing. It was two individuals who gave us the opportunity. We decided at the very beginning of this case that winning in court, which we hoped to do and we believed that we could do, wouldn't be enough. That our clients, at the end of the day, and we knew it was going to take several years if it got to the Supreme Court. We knew it was going to, and I have to one slight diversion. The defense of marriage case, the Windsor case that's been mentioned, meant all the difference in the world. And that case was on a parallel track. It wound up at the Supreme Court at the right time. It was argued by Robbie Kaplan of a firm in New York, and she did a fabulous job. The two cases have to be thought of together. But what we thought is that in a small way, we had to try to contribute to the change of the debate. We had to, public opinion at the time we brought this case was pretty much 17% against individuals marrying the person that they loved who happened to be of the same sex. And we felt that we had to talk about that issue. We had to explain why we thought. I wrote a piece called The Conservative Case for Gay Marriage. David wrote a piece in the Wall Street Journal. We tried to appear on television. And people would say, what the heck are you two guys doing together in the same courtroom? We thought you'd want to strangle one another, and you seem to like one another. What's going on here? So we said, okay, well, here's why. Here's why we're doing this together. And it gave us the opportunity to speak to the American people in a multitude of fora and explain why this was important. So changing the chemistry of a little bit gave an additional dimension and gave us an opportunity to talk about the issue because at the end of the day, we wanted this to be like Loving versus Virginia. In 1967, the Supreme Court decided, as David mentioned, unanimously that person could marry someone of a different race. And now we think, well, of course that's right. That's constant. That was never the case, was it? I've had prominent journalists saying, "Really, I don't remember. That didn't seem to be the case." So people accepted that decision They didn't accept Roe versus Wade so much. That's been seriously controversial, but we felt that our clients deserved our best efforts to try to shape in a small way, if we could, the public opinion in this country so that when they got married, which they did, 2 days after the decision in these cases, in San Francisco and in Los Angeles on Friday night, a marriage performed by the Attorney General of California for our 2 female clients in San Francisco, and if you see this movie, you'll see it, the mayor of Los Angeles marrying the 2 males. People were applauding, tears running down people's faces of joy. They deserve to be married. It is right for them in this country, for them to have the right to get married, and that 17% differential is now 15% the other way, not because of us, but because of lots of people talking about these issues. But we contributed in a small and an intangible way and an immeasurable way just because we were different faces, bringing different people to the same arguments.
We could continue, of course, all night, but there are a lot of people who want to buy your books and meet you. You mentioned that day on June 28th, 2013. There are pictures in this book of the couples getting married that are hard to read without emotion. And you also describe what Paul said the day after the Supreme Court victory. So today is a good day, Paul said. His voice shook with emotion as he touched Jeff's shoulder. Today, I finally get to look at the man that I love and finally say, will you please marry me? His eyes brimming with tears, Jeff answered him with a hug. David Boies and Ted Olson, thank you for having changed the meaning of the U.S. Constitution.
Thank you. Thank you. Great pleasure. Thank you.